Come on, really? Fucking prick.
Yeah, well, you don't have to. You could just put the driver's license away in a cupboard and never use it ever again, right? It's just a tool. It's just...
You said you have to surrender it.
Yeah.
So once you surrender it, you no longer license.
Then it's gone. And the reason for that is when you surrender it, again, the driver's license is just legal title to something that was another new thing that was created, right? It's all linked through the birth certificate. Now, anytime you split title and a trust is created, because one party has the legal title and the other has the equitable title, how do you collapse that trust? Put the titles back together. Return the legal title to the beneficiary title holder. There's no more trust. That's what collapses it. So when you surrender the title to something to whoever created it, you collapse that. There's no trust anymore. So you have the option of just saying this back and saying, nah, you know what, I'm never going to perform business as an agent to the government, ever. I don't require this. I'm just going to send it back so there's no more confusion ever possible as to who I am now. You could do that.
I was going to ask, you mentioned that there is a case that you have that gives reference to that statute's only applying to government or their agents?
Absolutely. R versus Big M Drug Mart Limited, 1985. And this is stuff that a friend sent me. Because he said, yeah, you're always talking about 32 and 52. Well, here's the case law. And I was like,
That's of the charter.
Yeah. Well, Section 52 is the Constitution, is part of the Constitution Act of Canada. So, Section 52 sets out the fundamental principle of constitutional law that the
Fucker. What the fuck? Oh, are you kidding me?
Constitution is supreme. The undoubted corollary to be drawn from this principle is that no one can be convicted of an offense under an unconstitutional law. Any accused, whether corporate or individual, may defend a criminal charge by arguing that the law under which the charge is brought is constitutionally invalid. And both the purpose and effects of legislation are relevant in assessing its constitutionality, and either an unconstitutional purpose or an unconstitutional effect can invalidate the legislation. A court not only has the power, but the duty to regard legislation found to be inconsistent with the Charter to the extent of the inconsistency as being no longer of force or effect. That's why I said earlier, they will pass laws that violate it, but that means they are of no force or effect. That doesn't mean they have to strike the law. It just means they can't actually prosecute you with it. They'll leave it on the law books, believe me, or they'll change names and they'll reword it a little bit, but so from there, then we go to R versus Dell. And R versus Dell. Now, this isn't part of the case law, or this isn't part of the decision. This is part of the writings of the book here, talking about number 32, and then I'll read the case law because it's only 2 lines long. The mere fact that an entity performs a public function, or that an activity may be described as public in nature, is not enough to bring it within government for Section 32 Charter purposes. For the Charter to apply to a private entity, not person, not man, not corporation, any kind of an entity. For the Charter to apply to a private entity, it must be found to be implementing a specific government policy or program. An entity may also be government not because of the nature of the entity, but because of the nature of the activity. So it doesn't matter who you are, you have to be, no matter what entity it is, it must be found implementing a specific function of government to be included in what they call government. R versus Dell, 2005. The Charter does not apply to interactions between private citizens except where the private citizen acts as an agent of the state or is performing a government function. You never need to leave those two pieces of case law, because 52 just said this charter is supreme, and anything that is inconsistent with the charter is of no force or effect. And they have the duty to make sure that they can't prosecute you with that at that point. Then we skip back to 32 right here, which just said the charter does not apply to interactions between private citizens except for the private citizen acts as an agent of the state or is performing a function of government. If the charter does not apply to interactions between the private individual, and it's the supreme law of Canada, how could any other law that they pass apply to the private citizen? Or a person, or an entity, a man, woman, anything. This is even just saying citizen. So even a citizen cannot have things done to it. That's the birth, even that. And that's when we get into the Bill of Rights thing I think somebody was bringing up earlier. What about the Bill of Rights? Well, yeah, it still all applies, because they still can't do the things that they do against you even when you're that. But they're doing it over here to you as well. So you never need to go over it. Then that's pretty cut and dry. That's from the Supreme Court. Is there a way to interpret that in a way that government can say, no, I think we can still come into your home and take your kids? No, absolutely not. So I don't need to go beyond that. That's it. So that's why I say I don't even get into any case law or statutes or anything in statutes, because once, if it's below these two things I just mentioned, then I don't care, because it does not apply, including definitions of words or anything. They have to prove I am implementing a specific government policy or program paid by the government, for the government. Can't get more clear than that, so I'm going to stop beating that into people's heads now.
Doesn't the Charter of Rights and Freedoms in itself say it belongs to Parliament?
Absolutely. And again, I talk about this in the videos. This is the Supreme Court sites that back up what I say. And I didn't even have those back then. I just, and actually another friend back in Manitoba put me onto that. We were reading through it and he's like, and we're like, okay, well, 52 says it's the Supreme Law of Canada. And this charter is it. This is the Supreme Law of Canada. Clearly, it's what created Canada. That's its mandate. That's its will. It has to obey that. Hang on a sec. So when you read through it, and section 52 says that this is the Supreme Law of Canada, anything that is inconsistent with any provision of this act is of no force or effect. Now, let's get something straight. Does that mean the government is not going to pass laws that conflict with that? It doesn't say they can't pass laws that conflict with it. They say that whatever laws they do pass are of no force or effect because of that. But only if you mention that. They pass all sorts of shit. Pretty soon they're going to be, your toilet paper roll is going to be a bill.
It already is.
Yeah, it basically already is. Okay? Does that mean it has any force or effect? No, it exists, but it is inconsistent with the Charter. So even though they passed it, it has no force or effect whatsoever if it is inconsistent due to the inconsistency. That's in the Supreme Court ruling. That's 2.5 lines long. Okay? The other one that's 2.5 lines long is regarding section 32 of the Act. So you go backwards. This is a supreme law. Anything that is inconsistent with anything in this is of no force or effect, even if passed and made an act. Then you go back to 32 and it says, this charter only applies to the government. If the charter is the supreme law of Canada and nothing can be inconsistent with that law, and it only applies to the government, how can anything passed underneath it, how can any subordinate act ever apply to something that is not the government? It can't. It's of no force or effect, which is just common sense to most of us. What do I give a shit about what they pass? How does that possibly compel performance from me in this title? Because they'll pass anything.